and we will send this recording to you also, and it will be uploaded on our YouTube as well as our website of Galta. So, Paki, please start.
Welcome, Prof. Hi everyone, a very good evening to all of you, to all the respected members of the Gajal family, and of course to Professor G.S. Bajpai. Thank you very much, sir, for sparing your precious time with us and coming up with this in conversation with part 3. In this conversation this time, we'll be talking about the proposed reforms in criminal laws of justice, where Professor G.S. Bajpai will be sharing his insights and will be sharing some answer to our questions. But before that, I would like to introduce Dr. Professor G.S. Bajpai with us. Sir serves as the Vice Chancellor of National Law University, Delhi. He is equipped with more than 30 years of professional experience as an author, researcher, teacher, and administrator. He has previously served as the VC of Rajiv Gandhi National Law University, Punjab, and Registrar at NLU Delhi. He has also served as the Professor of Criminology, Criminal Justice, and he is also acting as the chairperson at KL Arora Chair in Criminal Law and the chairperson of Criminology, Victimology at NLU Delhi. Before that, he also served as the professor and chairperson at the Center for Criminal Justice Administration, NLU Bhopal. Sir also served as the convener for the Committee for Reforms in Criminal Law set up by the Ministry of Home Affairs, Government of India, tasked with spearheading historic reforms in criminal laws in India. The Ministry of Consumer Affairs, Government India has nominated Sir as a member of the committee for conferring a statutory status to the right to repair under the statutory framework of the Consumer Protection Act in 2019. Professor Bajpai is also the nominated member of the Delhi Legal Service Committee of High Court of Delhi and has been nominated as a member of the State Higher Education Council in Punjab by the Government of Punjab. He is the member of the Advisory Board for Development of Legal Education, Legal Profession of Bar Council of India, a member of the Standing Committee of the Legal Education Committee of the Bar Council. He is also a member expert of the committee of the UGC to frame guidelines for introducing the course on law for holistic and multidisciplinary education. Sir has been designated as a distinguished visiting professor at West Bengal National University, Kolkata. Sir has authored more than 22 books, monographs, and more than 50 papers. Well, we welcome you all the due respect, sir. Thank you very much for being here.
Thank you, Paki, for giving a detailed introduction of our distinguished guest today, Professor Bajpai. Professor Bajpai, we at Global Academy of Law, Tech, Education and Research, popularly known as GALTER, have launched a monthly series in conversation, wherein we invite eminent experts from variety of fields to share with us in an interview mode his or her thoughts on contemporary legal and techno-legal issues. Earlier, we have conducted two interviews, one with Professor Sindhu Bhaskar, who hails from USA, and another with Professor P.S. Jaswal, currently the Vice Chancellor of SRM University, Sonipat. Earlier, he was Vice Chancellor of, as you know, Punjab Rajiv Gandhi National Law University. So, in this part, which is third part, it is our pleasure and honor that you have joined us for conversation. The theme of this conversation is broadly the proposed legal reforms in criminal justice system of India. As we all know that during the last monsoon season, which has ended a few days back, Honorable Home Minister introduced 3 new bills to replace Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act. And he has given the term Bharatiya Nyaya Sanhita, Bharatiya Dand Prakriya Sanhita, and Bharatiya Vidhi Sakshya Sanhita. It is said, and we are all debating over these bills, and there are divergent views about the need and justification of these views. I understand that you were engaged and you were consulted before the bills were prepared and presented on some of the aspects of criminal law. Therefore, I thought you will be the right person, most befitting expert who could throw some light on these laws. Because of the limitation of time, we will cover two laws, that is Penal Code, now it is known as Nyaya Sanhita, and Criminal Procedure Code. Professor Bajpai, my first question to you is, do you think that the proposed criminal law bills uh, will help in bringing speedy justice to the victims and will help in reducing the pendency of the cases, as it is claimed that simple procedure, time-bound procedures have been now prescribed. So what is your expert opinion on these points, please?
Thank you, Professor Bhandari ji, and thank you, Galter, for having me here today for this important conversation. Of course, we were part of a committee which has actually developed a very comprehensive report to provide a background to the criminal law reforms in the country with respect to all three major criminal laws. And this exercise continued for about 2 years. And there were a number of aspects with the team has been consistently working, and we tried to capture the most progressive forms of reforms in criminal law, and accordingly we presented the report to the I'll not comment on this process of report and what happened, but I'll come to your question directly. The extent to which these bills are capable of accelerating the adjudication process or the course of speedy justice, as you have asked. This is a question which we have actually been struggling for a long, long time to find the answers. And I believe that there was a need to look at both the laws as well as the institutions of laws to be able to actualize the requirement of speedy justice, which is of course the part of a fundamental right as well. Now, if we, so this question basically goes to the realm of criminal procedure code, which is now Nagrik Suraksha Sahita. So if you see that there are two very distinctive things which this BNSS has done. So first of all, they have introduced audio video technology across the board. I mean, at various stages of legal proceedings. So earlier it was limited to only some areas, but now all the inquiries, trials, appeals, witness testimony, all these things are covered, which means even in both session cases and magistrate trial cases, these proceedings ought to be recorded, and at every stage of explaining the charges, for instance, to the accused, can be conducted using this technology. This was never before. So this actually gives a lot of speedy push to the uh, sub process, which are the main reason of delay in most cases. So I believe that this mandatory introduction of audio video technology, of recording the proceedings, even for instance, electronic communication uses in someone issuing of someone in service, mandating the maintenance of personal details of accused and witnesses by the police and by the court official. So these are the compulsory things which are now part. So that is one. Second, you must have seen, again, I am addressing your question with regard to speedy justice. Now, this BNSS has provided a very strict time frame. So now all criminal process are bound by specific time frames. ensuring a swift case progression. So, like for instance, if you see the pronouncement of judgment after the proceeding, means decision on sanction, the time limit is 120 days. This is a statutory requirement. Similarly, like for instance, supply police file to the accused. Now, these used to be the major reason of delay, but now this has to be done within 14 days. Committal has to be done within 19 and 80 days. Filing discharge application, for instance, this has to be in 60 days. Charge framing has to be completed in 60 days. And also the pronouncement of judgment 45 days, uploading of judgment on court portal 7 days. And similarly, disposing the mercy petition, the mercy petition, how much time they have been taking even in death penalty cases. Now this has been bound by now time frame of 30 to 60 days. Now, third thing which is very important in this connection is mandatory summary trial. Now, this law has, the revised procedural law has introduced a very effective mechanism of summary trial. And now, if you see the mandatory summary trial now replaces with previous optional status for specific offences with property value limits increased to say 25,000 rupees. So magistrate can now choose to summarily try offences punishable with up to 3 years of imprisonment. This is a major change. And discharge proceedings are also introduced for summon cases, and also where the accused is continuously absenting, even the trial in absentia is possible. So adjournments are limited to two only, two adjournments maximum, because these were the reason. And these are granted after recording the reasons under circumstances beyond party control. So if you see all these things give a complete, framework in terms of timeline, because earlier version of laws were very hesitant to provide such a strict timeline. So I'm sure I have given a very brief coverage of this particular question,
Yes.
but there are many. So I suppose that this has a lot of potential to accelerate the process of justice.
Thank you, Professor Bajpai, for in brief but also in detail narrating various steps which could be time bound in as the trial advances and as the judgment is delivered. I am little skeptical about it. Uh, I know that there are many acts now, like Consumer Protection Act, where time limit is there, but those time limits have so far been not adhered to because of several reasons. In lack of infrastructure and many other regions, lack of proper judicial officer posted in time, vacancies, and all these things. So I wonder, but let us be hopeful. I'm always optimistic. Let us be hopeful. But I wonder the kind of infrastructure, net connectivity, especially in Mofussil area, and other infrastructure and vacancies lying in the appointment of judicial officers, even up to high courts. All these timelines would be sincerely and meticulously followed. If they are followed, I think really it will bring revolutionary changes and would get the speedy justice, and pendency will also get reduced. So my next issue I want to discuss with you is that in Nyaya Sanhita, it is said, I have also read it, but not in a very detailed manner so far, uh, that the sedition provision for sedition has been removed. The word sedition has been removed because Supreme Court also gave some directions. But in other format, the contents and the definition which has been given may be more even dangerous, or we may say maybe more susceptible to abuse by the enforcement agencies and investigation agencies. Since you are expert in victimology and other areas of criminal law, so can you please just throw some light on this sedition controversy in Nyaya Sanhita, that is IPC?
I partially agree with what you said, because this is the history throughout the world. that criminal laws are always susceptible for certain degree of its misuse. If you see Andrew Ashworth in the UK, the topmost criminal law expert, he said a just and rational criminal law is an unrealistic expectation of the public. Because what happens if laws are misused, the blame lies on the enforcement agencies. So institutions of criminal law and criminal law as such, there are two different things. We can produce a good criminal law, but it is in the hands of the agencies. But coming to specifically on your question of sedition, the first and foremost issue was before us whether to have an offense like sedition or not to have it. This choice is always with us. So we have chosen to have the sedition in a moderated form. The reason is that we are passing through a very disturbing phase. And this is a harsh reality of our times that we need to deal with people who are out to destabilize the integrity and security of the nation. And you need to deal with them. And when this is a reality, then you need to have a law also. But I was personally against the uses of the term sedition. I said this term connotes in Hindi Rajdroh. So there is no longer a monarchy. So we need not to have Rajdroh or sedition.
Yes,
But
yes.
we should definitely have an offense on the part of those individuals who are out to damage the integrity and security of the nation for whatever motivation. We need to have a law to deal with it. So in many developed countries also they have kept two types of law. One to deal with organized criminal, drug dealers, armed dealers, and one which is our little general offenses where ordinary people are involved. So this offense is addressed to merely those terrorist outfits or those organized criminals who have different motivation. However, one very important facet has been added to control the abuse of this provision, which was not there in the earlier version. Kedar Narayan judgment of Supreme Court on this subject was very, very useful. So we have decided to introduce a mens rea aspect, the criminal intent aspect. So
Yes.
now in the present version of sedition in the IPS, there is, so suppose I prepare a cartoon, I write an article against the government. Even the person can be arrested and prosecuted. Now this person may not have any mens rea or criminal intention to cause any damage to the security of the nation. Now, so first it would be honest will be on the enforcement agency to prove the fact beyond reasonable doubt. The proof of a standard is very also high that this act is somehow detrimental to the security of the nation. So testing this particular standard in itself is a honest, I would say, a very strong test, which would be a sort of a strong protection to the people. So now, so artistic and creative expressions against the government or against the state are completely out of the purview of this law now.
That is good. That is good.
Yes.
Thank you for enlightening on this controversial issue of Rajadroh. You have rightly said, where is now Raj? It is a democratic governance. So every small form of dissension not liked by the establishment should not be categorized as a Rajadroh. Yes, I too fully agree with you. Professor Bajpai, since you have been working long, and I read in one of your LinkedIn posts, because I am also very active on LinkedIn, that you have completed 100 newspaper articles, research-based articles. I do read your articles quite often, which are of my interest. I do read. So my next question is that do you think the fundamental question, though it has some political overtones, but I don't want to get political response in that. Do you think that these introduction of these three bills at the end of the parliament session, just before the end of the parliament monsoon session, was a political trick, uh, because elections are ensuing, so show the rosy picture, show that how the government is going big ticket reforms, and or it was really needed, uh, because these three acts are age-old British colonial era act, though amendments have been made time and again in all these things, but those were piecemeal amendments, and now it is a time that we should have wholesome amendment. And I don't know how wholesome they are. So what is your take on this?
See, this is a very good question because there are two aspects. First is the desirability of the reform as such. Now, there are three things we must notice which have been happening in the background of this reform. Actually, the demand of criminal law reform is not recent. If you look back, as yourself has cited, that we only had some piecemeal reforms in these laws in the past. We never have had any comprehensive legal reform with respect to any of these laws. So, like for instance, if you look at the last 2016, 2008,
30,
so
30.
so Justice Verma's context was because of Nirbhaya. So there was some haste to bring in changes in the law, and in fact, in our country, there was always some crisis which has necessitated, whether it was Bhauri Devi or it was Nirbhaya or it was other things. But I would say that there are three reasons which are clearly talking about the desirability of these reforms. So one is that there was a consistent debate and discussion within the academia, intelligentsia, and policy circles to consider certain aspects because our criminal justice system was continuously failing in meeting the public expectations. And whenever some probe was made, we always reached invariably to bring in some systemic reform, some criminal law reform, but they were never there. Third, if you see the Supreme Court judgments, continuously they have been talking about changes in the law. I have suggested at one point of time that please do not change any law, do not reform anything. You just factor all progressive Supreme Court decisions, automatically the reform will take place. So if you recall the D.K. Vasu judgment, for years together, this judgment has been serving as an important
Yes,
measure to provide guidance to
it's a
the
law
police.
laid down by Supreme Court.
Supreme
Yes,
Court. So
yes.
similarly on sexual harassment case, Justice Verma's
Visakha.
decision, Vishakha case, for
Yes.
years together, now Vishakha was implanted, DK Vasu was implanted, now we have Arnesh judgment on arrest, we have so many judgments. So I have actually said and I have very strongly advocated in our report that let us closely study all Supreme Court judgments, which have very in great details, they have provided great guidelines, like Justice Lokur's judgment on prison reform, in Ray, prison reform, so many. So I think these judgments were automatically talking the need of reform. You are
Reform.
not legislature was not doing, but judiciary was advocating in any case all such reform.
True,
So
true.
need for reform, to my mind, was always there. Now the question is the recent, introduction of these bills in the monsoon session. I would say people are knowing that they are being introduced in this monsoon session. But for instance, many of us knows that this process had started almost 2.5 years ago. Like I have been working for more than 2 years with these reforms, hundreds of meetings the ministry have had and hundreds of consultation we have had. I think it was a very, very long drawn process. I would say it was the longest process ever we had as far as reforms are concerned. The only thing that the everything got matured very at the very this time, so they have only this occasion to introduce this bill. Otherwise this process was already there in existence.
No, I think this question and this response was very essential, because
Yes.
people, ordinary people,
Ah,
they just think in a one direction. But what is happening behind the curtain, and how much efforts have been put to
Yes.
bring these bills, that you have very rightly clarified. And I think those who will listen or watch this interview, they will not raise this question again that it is more a political motivated initiative. I think you have very rightly uh, clarify that yes, the efforts were going on, and the Supreme Court has also contributed a lot in writing criminal jurisprudence and
Yes.
helping the victims and other people, stakeholders, in getting justice. Thank you for that, Professor Bajpai. Our Aparajita is also our Galter member, and Paki, who is working for Gartner as an in-house counsel, is also our Galter member. And I would be happy if people like you, learned and experts like you, are part of the Galter. We have so many vice chancellors as our members of the Galter. Some of them are regular members, some of them are honorary members, and we would be happy to have you with us as a team. I think, Paki, would you like to ask some short question as a coordinator of this in conversation? You can, please.
Yes, sir.
Very specific short question. Yes.
Yes. So my question to you is that, do you actually feel that the proposed changes are inadequate, and what are the further
I
steps
think
or
your audio is not very clear. There's a little difficulty in listening to you
Yes.
properly. Can you check it or speak little loudly so that sir can respond to it?
So I have written the question for your.
Okay. Yeah.
I will read. You believe that the proposed changes are inadequate and further measures are needed, correct?
Yes, sir.
Okay,
Yes.
please.
Yes. This is a very important question, and I have myself said in media also a couple of times that though these lot of changes are already there, but I would want at least 4 or 5 things to be necessarily, focused as far as the ambit of these suggestions is concerned. First of all, I want a more elaborate uh, introduction or induction of the victim justice aspect in the criminal law framework. Because at the moment, we have very little as far as victim is concerned. So providing a comprehensive placing to the crime victims in terms of providing certain rights, like right to participation, and also right to have a hearing at different stages of trial, would be very, very important, because the victim, because that would be in consonance with the international development, because a lot of legislative developments are taking place as far as victim justice is concerned. Incidentally, our laws are still in need of capturing a lot of such things in our criminal laws to provide the victim a central footing in the criminal law framework. So I would want this particular area to be definitely there. Second, I also want more sort of a robust arrangement to overhaul the system of prosecution. Prosecution continues to be a very weak link as far as criminal justice system is concerned. So I still believe that there is sufficient scope to streamline the agency of prosecution. Third, I believe that uh, the legal aid issue need to be very comprehensively provided. I am of the opinion that legal aid is not restricted at a particular stage. Legal aid is required at all stages of a criminal case. At the moment, our system of legal aid figures only at the time when trial is at the time of maturity. I would say even at the time of investigation, charge framing, cross-examination, sentencing. Legal aid is a continuous affair. Nobody has ever said, but I am saying legal aid ought to be a continuous affair and it should be provided at all stages of trial. And therefore, we need to have the provisions, explicit provisions in the law to make this arrangement. And last, I would say, which is again very important, and there are global discussion, even the discussion in India Supreme Court directions and decisions. We need to have a very strong arrangement of sentencing hearing. Sentencing is a very, I would say, ad hoc process as far as criminal trial is concerned. So it is also a very important, judicial hearing, which happens after holding the accused guilty. But it is routinely completed because there is no guideline, there is no statutory guidelines available how the sentencing should be organized, how the mitigating or aggravating factors should be underscored to be able to, and what should be the mechanism of collecting this information. So sentencing remains a weak area as far as criminal laws are concerned. So there are much more areas, I think, but these are few things which I definitely wish to point out.
Yes, Professor Bajpai, I fully agree with you on two counts. One is the legal aid is a continuous process and it should be available at every stage of the trial, right from investigation. And second thing, as you have said, our investigating machinery is same, that is the police. And same police personals, they look after the law and order, they look after the investigation of a crime, and there is no dedicated team. I think Law Commission and many other experts like you have suggested that we should have a dedicated investigation system with a dedicated, trained, technologically trained experts who can take the investigation, because that is the heart of the criminal trial. And the outcome of the criminal trial depends upon effective and correct investigation. So very rightly you have pointed out that we need wholesome reform. Initiation is good, beginning is good, but still there are lot many issues which you have rightly pointed out need to be addressed in our criminal justice delivery system. I must thank Aparajita for being a bridge between you and me in arranging this conversation. I'm also thankful to you, Professor Bajpai, for associating us in your G20 workshop. In fact, I joined online. Aparajita wanted me to come physically, but I had some other engagements. Sometime I will come again. Definitely, it would be my pleasure to visit NLU Delhi as and when appropriate occasion demands. And I will write you separately, but I think we can have, because we have decided to have a continuous dialogue on these three major reformatory laws, and we can have this in conversation is but one initiative. We are planning workshops on each law. We are planning national and international level sessions wherein we can invite experts from abroad. They can throw light on their criminal law system. So this is ongoing process, and I would request you to please help us and support us in this mission of continuous dialogue. With these words, I thank you, Professor Bajpai ji, for sparing your time on a working day and sharing your valuable thoughts on these very important bills. And we hope eventually with modifications, they would become the act and they would be operationalized maybe in 2024. Thank you very much. Thank you, Aparajita. Thank you, Paki. And thank you, Noor, for joining and witnessing this in conversation. Thank you very much. Namaskar.
Thank you. Thank you so much for having me here.
Thank you, sir. Thank you so much. Thank you, Professor Bhandari. Thank you, Paki.
Thank you.
Yeah. Thank you. Okay. So you have holiday in lieu of your successful convocation. So relax and enjoy.
Thank you.
Thank you very much. Thank you, sir.
Thank you, sir.